Davon Durant.
Good morning.
Good morning.
Good morning, Mr. Durant.
How you doing?
Ready to proceed?
Yes, we are. Yes, we are.
Sir, could you state your full and correct name
Davon Durant,
and your date of birth?
March 16, 1994.
On May 28th, you entered a plea of guilty to count 2 as amended, disorderly conduct, a class 1 misdemeanor and domestic violence offense. Your guilty plea was accepted and entered of record at that time. I read and considered the criminal history prepared by the probation department, as well as the defendant's sentencing memorandum and the letter from Mr. Walker that was submitted on Mr. Durant's behalf. What would the state like to say regarding sentencing?
Yes, Judge. The victim is present and would like to address the court. When you have the defendant step aside, Your Honor.
Mr. Durant, could you step aside, please, sir? Ms. Langley, would you like to come up to the podium? Could you begin by stating your name for the record?
Kelsey Langley. Thank you, Your Honor, for allowing me to speak. I just wanted to state that I'm ready to put the incident that happened between me and Davon Durant aside. I believe we've been through a lot, and the court's put us through a lot, and I'm ready to put it all behind us and move forward. You know, I would like to continue my relationship with him and continue however that may go. I'd also like to see him finish off school here at ASU. I know things have been really hard here, but I know I'm trying to stay optimistic with things, and we'd like to stay here and do it together. And I'd really like to have contact with him again. And thank you.
Thank you. Mr. Rodriguez?
Yes, Judge. In this particular case, the court's well aware of what the defendant was charged with and what the defendant pled to. The court has to consider the nature of the case in and of itself and where we are now, and kind of what also happened at the time of the incident and what brought forth this whole thing. Judge, there was a report of strangulation in this case. Strangulation is something that the state and the county attorney's office takes very seriously. When it comes to strangulation, women who experience strangulation are 7 times more likely to be victims of homicide. 10% of all violent deaths in America are the result of strangulation. In addition to that, 50% of all female victims of domestic violence homicides have reported being strangled in the past. I understand the defendant didn't plead to strangulation in this particular case. There was an allegation of strangulation in this particular case. The state believed the victim. There were injuries consistent with strangulation. There were injuries on the victim that support those charges. In addition, there are eyewitnesses who witnessed the assault or the attack on the victim in this particular case. Now, I understand the defendant is pleading to disorderly conduct in this particular case. However, the state's asking that the court impose 3 years of supervised probation with domestic violence terms, and the state will leave it in the court's discretion as to whether or not to allow victim contact. What was reported, what the grand jury indicted on, was a very serious matter, and the state takes it very seriously and asks the court to impose the 3 years of supervised probation. Thank you.
Thank you. Mr. Marcy or Mr. Taylor, what would you like to say?
I have nothing to add to the written recommendation, but Mr. Taylor does have material to add.
Yes, Your Honor. In regards to Mr. Davon Durant, the reason why he took the plea to take responsibility for this, he's never been more remorseful for this and everything. He's a student at ASU. He's currently a student at ASU. He's taking classes right now, and he wants to remain a student. That's his main goal, is to graduate from Arizona State University. We asked for a low amount of probation, Your Honor. 1 year would be appropriate in this case. Ms. Langley, you heard from Ms. Langley already. They want to be back together. She asked that Mr. Durant and Ms. Langley be a couple again. That's what they want. And people learn lessons in life, and he has learned a tremendous lesson. But he wants to remain a student at Arizona State University, which he is, and he wants to move on with his life. And he's a very respectful young man. he had a 3.3 GPA when he was in Kansas, and he transferred to Arizona State University. So he's a smart young man, has a bright future, and he wants to move on with his life and put this behind him.
Thank you. Mr. Durant, is there anything you'd like to say?
No, sir.
After considering the circumstances of this case, including the defendant's lack of any prior criminal history and the views of the victim, it is the judgment of the court that the defendant shall be placed on supervised probation with domestic violence terms for 2 years. As a condition of probation, the defendant may have no contact with the victim until he enrolls in the domestic violence treatment program as required by the plea agreement, and he may continue to have contact only as long as he remains enrolled in the program or successfully completes it. It's further ordered the defendant shall pay a probation service fee of $65 a month beginning September 1st, a probation assessment of $20, a $50 assessment to the address confidentiality program, a $50 family offense assessment, and a $20 time payment fee. Mr. Durant will receive a copy of the terms and conditions of probation, which you must read and comply with. If you violate any of the terms of your probation could be revoked and you could be sentenced to jail for up to 6 months. It's further ordered dismissing all counts and allegations identified for dismissal in the plea agreement. Mr. Durant, you have the right to petition for post-conviction relief from the orders of the court and to have a lawyer represent you. If you can't afford a lawyer, one will be appointed for you. If you can't afford copies of the necessary transcripts and records, they'll be provided to you at no cost. If you want to petition for post-conviction relief, you must file a notice within 90 days of today's date, or you lose that right. And when we're done here, please step over to the bailiff's desk to sign a copy of your rights to review and the conditions of your probation. Was there a bond in this case?
Yes.
I think there was. It's ordered exonerating any bonds. Anything else?
Nothing further.
No, thank you, Your Honor.
Okay.
We're ready on matters 10, 11, and 12.
Recall conference in all matters indicates a plea offer was made and expired. Settlement conference disclosure is complete.